Hi everyone, and welcome to the Litigation and E-Discovery ConfEx 2021, brought to you by Events for Sure. And my name is Zameer Nathani, and I'm very thankful to Event for Sure for giving me this opportunity. Uh, as a keynote speaker today on international litigation and dispute resolution strategies, uh, before I go forward with my subject, which has been given to me as a keynote speaker on international litigation and dispute resolution strategy, I would like to just introduce myself, a short, brief introduction of myself, and then I would give you the index of what I'm going to show it to you in terms of the content. Here is my introduction. I've done my LLB, I've done my LLM in civil, criminal, international law, WTO, United Nations. I've done my PLD from Harvard Business School. I've done my executive MBA from a renowned business school in India. I've done my IP law from Stanford University. I've done intellectual property rights and ADR certifications from WIPO, United Nations. I've done my private equity from London Business School and also mergers and acquisition from Harvard Business School. I started my career as a law firm attorney, serving renowned businesses in India and also MNCs. We have Eureka Forbes, LG Electronics, TCL India, Motul Oil, Ginger Hotels, Johnson & Johnson, and other MNCs. Post which I joined Reliance Company, where I was heading legal for the e-commerce, OTT, and gaming business, which had started in 2006. It was just ramping up on the international platform, what we hear about Amazon and Netflix growth today. I then went to become the chief legal officer for a very renowned TV show company in India, a public listed company. I was then chief legal officer for world's #2 worsted textile company based in India. It's a 90-year-old company. And presently I work for UFO Movies, which is a public listed company. This is one of the finest companies which disrupted technology. And we had cinema theaters, or we had movie theaters, where the physical reel of Kodak was replaced by a digital projector. And that's how you can now see the movie on same day and same time in any part of the world. I'm also a recipient of the Harvard Business School Alumni Challenge Award. And in addition to the other multiple awards which I have in my career, I still have one of the best ones as General Counsel of India, which was awarded to me by Justice Sri Krishna, who's a retired Supreme Court judge, and he was also the chairman of the Committee on Data Protection Law. With this, I go to my topic for discussion today. As a keynote speaker, I would give you highlights of the subject which I'm going to discuss, just to leave you with the thought process of what is the futuristic dispute resolution techniques or the mechanism we are going to see now. We have been seeing traditional courts. We need to somehow come out of that, not from a perspective of adjudication, but from a perspective of time efficiency, more professional approach. Those are the kinds of things which we are looking at. I would first discuss about emergency arbitration, which is new to India, but was recently upheld by a court, by the Delhi High Court in India, in spite of the fact that the emergency arbitration is not included under the law of India. And even in the parliamentary process, it was said that we don't intend to have this legislation as part of the Arbitration Act. But still it was upheld by the Delhi High Court on the basis of the Emergency Arbitration Award, which was given by SIAC recently in a big judgment. I'll come back to it in a second. We will then see the pre-trial mediation, which is one of the techniques, futuristic techniques we should evaluate. Rent a judge is a concept which is now flourishing. To use the term itself is somewhat thinkable, but we have tried to give a time-bound meaning to it. mini trial or summary trial, e-filing and court communications, case scheduling, Lok Adalat, which is like an out-of-court judicial settlement process, community dispute resolution program, and case management. So this is what I'm going to bring before you in my keynote. I'm going to give you bullet points as a thought process. This is what the futuristic outlook we are looking at. All right. I first go to my the topic of the day is about the emergency arbitration. There was a big dispute between Amazon and Future Group. They had a collaboration in India where Amazon had taken over the retail business of Future Group. Future Group also entered into a similar agreement, which is an asset purchase agreement, and this was a share purchase agreement with Reliance. And Amazon went to Singapore International Arbitration Center, stating that they had a specific agreement under the contract between Amazon and Future Group, where there was a non-compete clause which also included the name of Reliance, and therefore doing indirectly an agreement in some other name or by some other interpretation amounts to the same thing. It's a violation of non-compete, and if deal is allowed to be proceeded, then there's a problem to it. The Singapore International Arbitration Center immediately appointed an emergency arbitrator. The emergency arbitrator immediately passed a stay order saying that the deal between Reliance and Future can't proceed. And this order was challenged by the Future Group in Delhi High Court, where the Delhi High Court said that emergency arbitrator's award or the order which has been passed for temporary stay, we are not going to interfere with that. This is one of the things which have become most important, because there are kinds of relief we are expecting at the earliest. If not, then the purpose would be dislodged. There are some provisions under the law, but emergency arbitration, emergency arbitrator passing an award within 24 hours to 48 hours is something which is very important and critical to a point where high stakes are involved between the parties. What are the merits of the matter will be turned up later on, but this really has made a difference in the litigation strategy of Amazon. The aim of this emergency arbitration was basically that the parties can't wait for the formation of arbitral tribunal, the arbitral tribunal then going to look into the matter, saying that let us examine whether an emergency stay can be given, etc. So emergency arbitration and arbitrator appointment by Singapore International Arbitration and passing that order within days is a significant litigation development, arbitration development, significant strategy which was used by Amazon to invoke the provisions and get the stay order in favor of Amazon. The efficacy of the emergency arbitration, once it is invoked by a party, survives on the two wheels of a chariot, as we say. One is a reasonable possibility that the requesting party will succeed on merits. And number two, if the measure is not granted immediately, the loss would not and could not be compensated by way of damages. So there are substantial impact on the deal which is there between the parties, and even the damages can't suffice to that extent if the other party goes ahead with their deal. All right. Now, what are the powers which are vested with the arbitrator? The emergency arbitrator shall, as soon as possible, but in any event within 2 business days of appointment, establish a schedule for consideration of the application for emergency relief. So a schedule shall provide a reasonable opportunity to all parties to be heard. It may provide for proceedings by way of telephonic conference or on written submission as alternatives to formal hearing. Due to strict timelines, the emergency arbitrator may never actually hear or consult with the parties apart from certain major clarifications, and simply give his order on the basis of the documents and written submissions placed before it. New concept in India and globally. It becomes an example, because if big deals have such orders which are passed by the emergency arbitrator, it then becomes a trend that instead of getting a relief before the court, why not proceed before the emergency arbitrator and take the stay order within 2 working days. Timelines, as we speak about, do vary under international arbitration rules, but a typical emergency arbitration takes around 8 to 10 days from the date of application to the date of award. The emergency arbitrator shall have the powers vested in the arbitral tribunal pursuant to these rules, including authority to rule on his own jurisdiction, even if you question the jurisdiction. This is what exactly came up. It was said in the Delhi High Court that emergency arbitration is an unheard concept here in India. The legislature itself, when the laws were drafted on arbitration, did not put emergency arbitration under the law, and therefore this should not be granted at all. The emergency arbitrator himself has an authority to take a call on the jurisdiction and pass such orders. The nature of the interim orders include asset freezing orders, both prohibitive and mandatory injunctions, orders for the preservation and inspection of evidence, preventive orders to avoid misuse of intellectual property rights or confidential information, as well as anti-suit injunctions. All right. So broad powers. You file it within 2 days, the cognizance is taken about it. Within 8 to 10 days, you have an award from an emergency arbitrator on the issue of emergency relief, what is expected by you. All right. This is a complete new trend in the litigation strategy, in the arbitration strategy before us. The next mechanism, what we are seeing today, is pre-trial mediation. All right. Concept is well known. It's been developing for some years, but now it's become a pre-practice, and it's a very good development which has happened, because mediation, as known to us in the legal parlance, is always that reality check, whether the party will be able to do that, whether the evidence is sufficient enough to take cognizance of that. All right. Now, while this subject is now picking up, the important part of it is that there's a time and cost efficiency which is there, because you are saved by expensive litigation, expensive arbitration, reduced burden of courts and pendency of matters. In India specifically, Section 12A of the Commercial Courts Act 2015 now makes it mandatory a pre-trial mediation. All right. What an important step taken at the legislature's end, where a pre-trial mediation is taken place. Parties understand the context with which they are going to fight this case. They understand what are the evidences which are involved. They know the reality checks. They know what is favorable, what is not favorable, how far the fight could go on, how far the damages could be claimed. All right. So the law itself now making a pre-trial mediation mandatory is subjectively one of the best things which has happened in the legislation. One is that arbitration tribunals and judges and juries are uncertain at best. I was sitting with a Supreme Court judge at a forum, and when I was speaking on arbitration and the judge was to speak on the litigation, he said, no lawyer, no jurisdiction can give you a guarantee that if you have won the case in the first court, or if you have won the case in an appeal court, whether Supreme Court is going to also uphold that judgment. All right. And therefore, the uncertainty is at many times looks like, I've given some example of Las Vegas so that to make it a little lighter. But it's about Las Vegas, it's about casino, whether you are going to win at the end of the day or whether you are not going to win at the end of the day. Going to arbitration or to trial, there are no certainties in that, which is a fact we all are aware about it. Secondly, as the litigation goes on, the relationship between the parties deteriorate even further, because there is no pre-trial mediation, there is no conciliation, there is no caucus where the parties, mediators and advocates sit down, or the lawyers are sitting down, they're explaining the realities, etc. It gets deteriorated day by day, and as dispute becomes more complex, the dispute escalates, and it's completely out of context between the parties. Of course, one of the most compelling reasons for early mediation is also the expense in hotly litigated matters, which really makes a difference. I have seen it in my corporate career. There are litigations between the promoters, and they really cost money to it. It's better to have mediation so that it can be sorted out at a more amicable terms. The third concept which I want to bring to your notice is about rent a judge. It's a fact. This is a website which you're saying. It's a live example of it. The terminology seems to be little on the wacky side of it, I may say, but it's all about time-bound judge. I mean, this is what we are going to speak about, and that's where the concept of rent a judge comes in. There's a distinction between traditional arbitration or litigation and rent a judge model. Enforceability of the judgment and award, efficiency in terms of cost and time, and party and autonomy about it. The objective is that you appoint retired judges as the moderator to resolve the conflict. It's like a private tribunal. All right. Fixed time for pleadings and orders. Power is vested similar to that of a civil judge. Now, this is the concept we are talking about. It's about rent a judge. The retired judge sits as a moderator, listens to the merits of the case, and decides as early as possible. And these orders are enforceable in the courts of law. The next concept I have is about mini trial or summary trials, because when we talk about trials, we see a number of years coming in front of us. But let's now introduce the concept of which is known as mini trial or summary trials. When you talk about mini trials, it's about less time consuming than the regular trial process. Parties exchange of documents prior to the trial process. So there is exchange of documents not at a later stage, but even before the trial process starts, they will exchange the documents. Fixed time is allotted for pleading, and there's a fast track judgment. So parties exchange the documents before the trial process. Fixed time is allotted for the pleadings, and there's a fast track judgment which is happening, and that's what we call a mini trial or a fast track trial. Okay. The next concept which I want to bring to your notice, concept number 5, is about e-filing and court communication. It's high time that things become fast track, things become efficient. We require efficiency not only of the judgments but also efficiency of the process, because a lot of time sometimes is wasted in that, and a lot of communication gaps also has been seen in that. If you follow the mechanism of e-courts, it's about convenience and savings for the government as well as the public. Easy access to documents, it's all there on your screen, sitting on your laptop, whichever location you are there. Time and cost efficiency is there. Ease of litigation process is there, and the procedure is there. Supreme Court of India has now adopted, we are thinking about hybrid model also being executed. There is an e-filing website and a virtual hearing which is taking place. All right. So first we started with virtual hearings, and then e-filing was in the process. People thought, how will we find such huge documents before the court? And today here we are. Pandemic has opened up everything, every avenue for us. We've started e-filing, we have started filing documents, we get e-numbers, there is a e-pagination, e-corrections which are happening, and then it goes before the Supreme Court and other courts in India for a virtual hearing, and you get orders passed by the virtual courts. All right. In 2016, I wrote my first article on e-courts, and the 2016 article of e-courts was basically convenience and savings for the government and public. I never thought that pandemic would make it a reality, but we thought, why not try this process, because we are in the age of electronic world. Okay. We can have e-courts by using indigenous services or services of good, well-known companies. I want to specifically name it. They have been used by all the courts in different jurisdictions globally, like Cisco, WebEx is there, Skype is there, Nokia is doing it, etc. Of course, under the security cover of NIC of Government of India. So when it comes to Government of India or the India jurisdiction, they have a body known as NIC, which takes care of the cyber security, and every jurisdiction then has its own. Conduct e-hearings in cases where required. Traveling to the courts may be convenient for some, but inconvenient for many. It's a fact of life, we all admit that. The courts can always call parties for important days and on order day. In fact, courts which are for petty matters should have online payment of fines, and no special court should be open for that purpose. It's a cost not only of the real estate, it's a cost which is inconvenience to the government as well as the public in terms of time, cost, and convenience. All services of documents like application, plaints, complaints, replies, affidavits, etc. can be electronically served to the concerned person or their lawyers on record. Email communication is now existing for the last 20 years. Let's exercise, let's acknowledge the reality of life and avoid physical copies as much as possible. The next concept which I want to show is about case scheduling. Very important, case scheduling. Whenever there is a case which is filed, so some years back we used to have jokes about that, you can file case about it, but filing a case in court is unlike an airline. So what is the similarity between an airline? An airline has a takeoff time and a landing time, but when you are in courts, you may probably know the takeoff time, but you may not know what is the landing time. Okay. Now, case scheduling is one of the mechanisms where we can improve our litigations and arbitrations. We can have a scheduling of the case at the time of filing itself. It should be a time-based pleading and orders, promising end of litigation process at some point of time. We need to now get up. We need to know what is my first date, what is my last date before the Supreme Court. I go to the first court, there is an appeal court, there is a high court, there is a Supreme Court. I need to know that if this matter is dragged on till Supreme Court, what's the time schedule I have, and therefore I can plan myself to that. The next thing which I want to speak about case management is that the case management facility should be available from the original suit to the Supreme Court. Like I said, I need to know today that when I file a case today before the first court, what will be the time which will be taken, the dates which are given to me, those are tentative dates, but I figured out that I know the dates, and therefore I would plan my responsibilities in that way. And if this goes in appeal, what is the last day to which I can bring end to the litigation process? This will really build up confidence in the judicial process. Submission of the case at the time of filing for submission of documents to pleadings to judgments. Time-based pleadings and orders. 20 minutes per party for pleading in addition to prior written submission. We make a written submission, we stand up in the court, argue the same thing which is already written in that for next 2 hours. I think we should somewhere down the line adopt a practice that what's already written has been read by the judge, unless you want to point out much things which are very important. But we should have a scheduling of 20 minutes for one side and 20 minutes for the other side. Somewhere down the line, we need to get up with the time limit. We must remember one thing, that persons coming to court generally is working or employed somewhere and must leave aside his or her work and routine schedule, which it hampers his or her full day schedule. The above will also give confidence to the person filing the case and to know the procedure involved, which it will go through with hearings, dates, and timelines when the case will get over. All right. This is building up confidence in the judicial process and the professional approach we have. Uh, the next concept, which is well known here in India, is about Lok Adalat, which is out of court settlement under judicial process. Uh, you have amicable compromise at a pre-litigation stage itself. So the litigation is filed, and you are not going up to that mark. Prior to that, the pre-litigation stage itself, there's a compromise which is happening. You're saved of the burden, you're saved of the complexities, you're saved of the time and money and expense which are associated, and of course the longevity of the case which it will go on. There are levels and compositions of Lok Adalats for various subjects. Amicable settlement and out-of-court settlement procedures are completely streamlined. It's a very great principles on natural justice. It's a time where you settle the case where something is genuinely due and close the matters so that your complexity of the life also reduces with the reduction in litigation. The second last concept which I have is community dispute resolution program. Now, when you think about community dispute resolution program, these are some litigation and arbitration strategies which are really helpful and working out. I was one of the board members of a community litigation, arbitration, mediation, and conciliation process. And I can tell you the success ratio which we had got in the settlement case being executed was 100%. Community dispute resolution program really works. Once parties enter into settlement, the success ratio was 100%. Now, this is the advantage which is happening around, and I think we should really put that as a strategy and execute it at a community level. It may be at a community level, it may be at an industry level, it may be at a level where parties can sit down, and it can be a joint and several discussion and decision which can be taken between the communities of the industry where we are working on. Now, community volunteers and party autonomy, efficiency of cost and time. We have a lot of chambers of commerce which do this. Affordable for those who cannot spend on costly litigations and are willing to keep relations intact. What a difference it makes to it when somebody says that we have a ratio of 100% success. The last which I have is about case management. Now, this factor I wanted to bring to your attention is because this was highlighted by one of the most reputed senior counsels of the Supreme Court of India, Mr. Harish Salve. He's also a barrister of law, QC. He has given certain suggestions to Supreme Court of India, which I really want to bring forward to you because that's important part of the litigation and arbitration strategies we are looking at. So one suggestion was that there is a chapter 3 in the rules of civil procedure code with form of pleading. The power should be used to simplify pleading. We should not make things very complicated because complexity increases the timelines, the bandwidth, the confusion about it. Plaint shall be accompanied by statement of claim, and the written statement shall be submitted with the statement of defense. Why to have segregation of it at a regular intervals? Why not collate whatever you have on the plaintiff side, on the defense side? It must be to the point and not full of stories. Pleadings should be flexible and allowed to be amended at any point of time, so long as it does not require further evidence. We should get away with this practice of saying that, all right, you did not put a full stop, I will not allow you to pull a full stop. If pleadings are naturally admissible, I think we should allow that flexibility to be amended so that there is not a pressure of saying that, you are coming out with something as a defense, which is rightfully not there in that, and natural justice will be denied. So that flexibility should be available, so long as it does not require any further evidence and it's not a Blair statement itself. Two significant changes has been amended to require filing of the list of documents and photocopies of all documents in its power, possession, and control pertaining to the suit. Problems related to the issuance of summons should be dealt with the administrative side and not the judicial side of it. These are all administrative functions which should be administratively dealt with. You have now WhatsApp, you have email communications, administrative side should completely take care of it. Judicial side should completely concentrate on the judicial productivity of the matter. A replication of the documentation should be considered as a fossil of the past. We keep on putting same, similar, identical documents. I think this should be considered as a fossil of the past. Limiting the filings may prevent a malpractice of running a new case in replication. A widely used document in commercial arbitration is known as red fund schedule. So if you see red fund schedule, the same concept must be applied, as it will assist the court where parties produce the following documents on narrow or specific categories of documents that are reasonably believed to exist and that are relevant and material to the determination of the case. So the idea which has been portrayed here is that make a simplified pleading, don't make it complex unnecessarily. Have a red fund strategy where you have such limited documents which are reasonably believed to exist and that are relevant and material to the determination of the case. These two things will narrow down so that the judicial process by which the judge is going to interpret the merits of the matter, the judicial is not burdened unnecessarily with such materials which will make the process very complicated and complex for the judicial body to adjudicate the matter. As you see, Order 13A, that completely provides is another significant change which has been made in the Civil Procedure Code of India. It allows a party to file an application to strike out issues or claims or defenses that have no real prospects of success. We keep on writing some grounds which we feel that it's meritorious, but end of the day, then we realize that it's nothing but something which is ridiculous. It's not going to be upheld. And let's strike it down. Let's narrow it down to the real moot point where you expect the relief to get and where there is an appreciable evidence to prove your matter, because that's the responsibility of the judicial adjudication which we have as lawyers, so that we don't overburden the judiciary with unnecessary complex materials. Recording of evidence is addressed in chapter 11 of the High Court rules. A list of witnesses shall be indicated at the beginning of the case with brief over what evidence shall be led by the listed witnesses. The discretion shall be of the judge whether to allow or disallow a witness. All right. This was one of the things which was also affecting, because people had a long list of witnesses, some 300, 400 witnesses in some cases, and unnecessarily burdening the judicial process, which now has been brought to a stop by virtue of these rules which are there. Considering all these things, what I really see in the forthcoming process, where you speak about international litigation and dispute resolution strategies, I think this new era of handling cases in a different manner than the traditional mechanism, without affecting the judicial sanctity and productivity of it, making the pleading simple, applying mini trial mechanism, emergency arbitration coming up as a new strategy, so that your emergency matters are handled. 2 days is the processing time. Within 10 days, you have an emergency arbitration award giving you a stay in your favor, so that you are not affected by anything which can go out of hand during the judicial process or the arbitration process, which would take time, certainly, because to evaluate the merits of the matter. I think these new ways, what we just saw, will go a very long way in making the litigation and arbitration process not only strategically sound, but also bringing down the timelines, making it more professional and efficient, giving that confidence to the public and the industry that the arbitration and litigation process is really sound, professional, fast, efficient, and it also saves at some point of time, cost, and gives convenience. I think these are the long-term and the futuristic mechanisms we are looking at, where we should see that international litigation and dispute resolution strategies will be successful. They're all forward-looking. I think 5 years down the line, we will have these processes completely and professionally in place. And I think that's the great sign for the legal fraternity itself. Thank you very much to Events for Sure once again. Thank you to my audience. It was a pleasure to speak to you. I will take any questions which you have later on. Thank you very much.